So in the second part of these three recordings, we had just discussed quasi-universal jurisdiction. So let's move now to discuss universal jurisdiction. So the key point about universal jurisdiction is that it is not based on links. So this involves a state prosecuting a crime where there is no type of territoriality, nationality, protective interest, or registration-based jurisdiction involved. So it's an extremely expansive concept of jurisdiction, so it's only available for limited categories of crimes. And it's certainly available for piracy, war crimes, genocide, and crimes against humanity. That may be a narrow list. There may be a broader range of offences that it is available for, but that would certainly be the core offences which every state can exercise universal jurisdiction over. In our study of the arrest warrants case, a number of controversies are highlighted. The first is this idea that if states can just all assert jurisdiction over certain crimes, then it may lead to chaos, that this may be too broad a concept and it might need limits. And a principal suggestion is that states should perhaps not be able to take any action under universal jurisdiction until the accused is territorially present, is within their territorial space. This is sometimes contrasted to the idea of universal jurisdiction in absentia, which is not necessarily conducting a trial without the presence of the accused. It's about commencing legal proceedings without the accused already being on your territory. Now, if in absentia jurisdiction, as some suggest, is inadmissible, the question then becomes, well, what counts as exercising enforcement jurisdiction in such cases? And that's something we'll take up in class. What can you do in order to try and secure the presence of someone accused of a universal jurisdiction crime? Are you able to issue, for example, an arrest warrant? So that concludes our review of principles of prescriptive jurisdiction. Let's turn now to enforcement jurisdiction very briefly. The power to take coercive measures to enforce your national law. Now we need to distinguish between territorial enforcement action and extraterritorial enforcement action. Now, territorial enforcement, there's a very simple rule. Unlike prescriptive jurisdiction, where states can take extraterritorial action on all sorts of bases, enforcement jurisdiction is ordinarily and strictly territorially limited unless an exception applies. So extraterritorial enforcement requires either the permission of the territorial state, so perhaps a cross-border hot pursuit agreement, where one state has given another permission for its police to cross a border to maintain contact with a suspect and prevent them escaping. Unless you have the permission of the territorial state, you require a special permissive rule of international law to take action, law enforcement action outside your territory. So, permission of the territorial state or a special permissive rule of international law. The most obvious example being piracy, where all states have jurisdiction to take enforcement action on the high seas. Now, the question then becomes, again in the arrest warrants context, without a special rule, what will count as an impermissible act of enforcement? So is simply requesting states to take action within their territory somehow an act of extraterritorial enforcement jurisdiction or not? These are some of the questions that are relevant to bear in mind in your reading and that we'll go over again in class. So that concludes our presentation on jurisdiction.